Hey besties, welcome back to the channel. It's Katie Joy. So, I had a feeling something was coming, because it is very clear that things behind the scenes at the Reynolds Lively house are anything but calm right now. After the unsealed audio between Claire Yubb and Steve Sarowitz became public, Ryan and Blake were probably panicking because what we actually heard in that call does not match the story they've been pushing for months. That recording was supposed to make Blake look like the victim of a toxic workplace. It was supposed to support her claims that there were others coming forward with complaints about Baldoni and that she had been mistreated by Wayfair and by him personally. But instead, it undercuts her entire narrative. The tape shows this wasn't about harassment or discrimination. It was about power, control, and Blake trying to dictate the marketing, media narrative, and public perception of the film once backlash started rolling in. It lines up with all the weird distance we saw during the press tour, the passive-aggressive messaging, and the behind-the-scenes maneuvering we now know was happening long before anything went legal. And conveniently, this is also around the same time Blake and Ryan were demanding that Wayfair put out a statement taking responsibility for the backlash. Plus when Jones suddenly turned over phone data that wasn't even hers to access. So what's Blake's next move now that the headlines aren't flattering? Her team files a motion for sanctions, accusing Wayfair, Wallace PR, and the others of spoliation, basically saying they destroyed evidence. She now claims they used Signal, auto-deleting voice notes, and encrypted threads to secretly coordinate a digital PR campaign to bury her publicly in late 2024. She says these messages mocked her, strategized against her, and were designed to tank her reputation, and that they intentionally deleted everything before litigation. The problem? She has no actual evidence these specific messages ever existed. No screenshots, no metadata, no backups, nothing. Just, I believe they existed, therefore assume the worst. But she wants the court to pretend those messages were real and rule as if they contained incriminating proof. She's asking for an adverse inference instruction, meaning the judge would tell the jury they are allowed to assume the missing messages prove her claims. Issue preclusion, blocking the defendants from even denying the digital campaign. Jurisdiction over Wallace based on deletion alone, which is a stretch. And of course, payment of her legal fees. All of this is happening right after she told the court she had thousands of pages of evidence ready to amend the complaint and prove everything. But now suddenly she doesn't have the evidence and needs the court to fill in the blanks for her by punishing the other side. So which is it? To actually win sanctions under Rule 37E, she has to prove the evidence actually existed. The other party had a duty to preserve it. It was lost because of their failure. It cannot be replaced. And that they intentionally destroyed it to sabotage her. That last part, intent to deprive, is the highest bar, and right now she has speculation, not proof. And that is where her entire argument starts to collapse. And this is where Blake's legal strategy starts looking less like a strong case and more like a pressure tactic. She's not just asking the judge to consider that maybe evidence was deleted. She's asking the court to pretend that the missing evidence definitively proved her claims, even though she can't show that it ever existed in the first place. That's the legal equivalent of saying, I don't have receipts, but if I did, they'd prove I'm right, so punish them anyway. Courts hate that, especially federal courts, because if the judge grants her request, that would mean anyone could accuse a defendant of deleting evidence with zero proof, then automatically get the jury instructed to assume guilt. That would open the door to abuse in every civil case, and judges know it. And remember, she's already filed multiple extreme motions. She tried to sanction Friedman and implied he should be disbarred. She asked for a default judgment to make her the presumptive winner before trial. She demanded the defendants basically be gagged from presenting any defense. Now she wants a missing evidence, I automatically win instruction. At a certain point, this stops looking like litigation and starts looking like scorched earth leverage. The contradiction is also glaring weeks ago. We have thousands of pages proving everything. This week, we don't actually have it, but assume it existed and punish them. Federal judges are not blind to those timeline problems. Where this likely goes next. For Blake to win on this, she must prove the specific messages existed. They were relevant. The defendants knew they had a duty to preserve them. They failed to suspend auto-delete in bad faith. And most importantly, they did so with the intent to deprive her of evidence. Right now she has assumptions, coincidence in timing, and speculation about conversations she thinks happened. That is almost never enough to get a Rule 37E sanction, let alone the harshest version, an adverse inference. The judge is far more likely to say, "Come back when you can prove something existed." The real problem for Blake. By filing sanction motions this aggressive without evidence, she risks looking like she's weaponizing the court, undermining her own credibility, signaling desperation, making the case about process, not facts, and irritating the judge. Once a judge starts believing you're using the court as a PR tool rather than a legal one, it's over. And this is where the danger really starts creeping in for Blake Lively legally. Because when a party overreaches in sanction motions, it can actually reverse sympathy in the courtroom. Judges don't like when litigants try to turn missing or speculative evidence into a guaranteed verdict. Right now, Blake is effectively saying, "I can't prove they deleted anything, but assume they did, and assume they did it to sabotage me, and assume it proves my entire case." That is a massive legal leap. Even worse, she is trying to apply the harshest sanction without first clearing the lowest threshold test, proof the material ever existed. It's like demanding the death penalty in a case where there isn't even a confirmed crime yet. Why this is already backfiring. When you ask for punishments this severe without producing receipts, judges start asking themselves a simple question. Why are you asking me to assume the evidence? Where is the actual evidence? If she really had a conspiracy, a PR plot, targeted retaliation, and coordinated harassment, there would be at least some trace somewhere. Screenshots, backups, third-party recipients, forwarded logs, depositions, metadata, forensics, anything. Right now she's saying, "I know they had it, I just can't show you, because they destroyed it, so you should declare me the winner." And that's where judges start treating the motion as strategic theatrics, not substantive law. Even worse for her, the intel flip. By filing this kind of motion now, Blake unintentionally told the defense exactly where she's weak. She has no time-stamped backup. She has no digital forensic report validating prior existence. She can't tie specific users to specific deleted threads. She can't show intent to deprive, only, "I think they meant to." That means the defense now knows the gap, and they can weaponize it against her later by arguing, "She admits she has no proof, just accusations." That undermines credibility, which is deadly to a plaintiff who is asking the court to trust her narrative over hard evidence. Irony: Baldoni's team benefits by staying silent. The smartest strategic move Baldoni's attorneys have made so far? They're not reacting emotionally. They're letting her overplay her hand. When a plaintiff keeps filing escalating sanction motions without proof, it becomes easier later for the defense to argue. She is litigating through press strategy, not fact strategy. She is trying to create smoke because she has no fire. She is using court filings as PR leverage. She keeps trying to win by procedure instead of evidence. That argument hits especially hard in federal court. Judge Lyman has already made it clear that simply using auto-delete is not enough to prove bad faith. To win sanctions, Blake would have to show deliberate destruction after a legal duty to preserve was triggered, and she never sent a preservation notice. The letter she keeps referring to from November 2023 was about her return to work protections and alleged harassment, not litigation. It wasn't a legal threat, and it didn't order anyone to retain communications. At most, it said she reserves all rights, which courts do not treat as a preservation demand. This is why her filing is already on shaky ground. On August 29, 2025, Judge Lyman addressed this exact issue. Blake asked the court to compel Wallace and others to produce old Signal chats or explain what happened to them. The judge refused, ruling that a party cannot be compelled to produce documents that do not exist, and Blake had provided no proof those specific communications ever existed in the first place. He also accepted that Signal's auto-delete was enabled and found no evidence of intentional destruction. That should have been the end of it. But this new motion is essentially the same argument repackaged, just filed after the Unsealed audio cratered her credibility. And that's the pattern. Every time her case narrative takes a public hit, she immediately pivots to sanctions. When the Van Zandt dispute collapsed, she threatened Friedman. When PR strategy emails didn't land, she subpoenaed Friedman's firm. When the press narrative flipped, she filed safe harbor threats. Now that the audio contradicted her harassment framing, she files another round of sanctions. It's reactive litigation, not evidentiary litigation. They also clearly knew the audio was about to become public. They needed something on the docket to reframe her image before the media coverage worsened. But instead of rebuilding credibility with facts, she's asking the judge to fill in the gaps for her, to assume deleted messages existed, assume they were incriminating, and assume they were destroyed intentionally. This might play as a PR soundbite, but it does not hold weight in federal court. Because to get the sanctions she wants, she must prove the communications actually existed. Defendants had a legal duty to preserve them. They failed to take reasonable steps. The data cannot be restored or replaced. They acted with intent to deprive her of evidence. That fifth requirement, intent, is almost impossible for her to reach without at least some independent evidence. And Judge Lyman already ruled that there is no proof the messages existed in the first place. Auto-delete alone is not malicious destruction. She never triggered a legal duty to preserve. She is speculating, not proving. She keeps pointing to sealed and redacted filings as proof, but the public only ever sees half the story. And the judge has already said that half isn't enough. At best, she might get a limited acknowledgement that some data wasn't preserved. But these sweeping jury instructions she's requesting, telling the jury to assume deleted evidence proves her case, are extremely unlikely to be granted. It also doesn't help that the timeline exposes the motive. The sanctions motion wasn't filed when she first learned of missing signal chats. It was filed after the audio release devastated her harassment narrative. That makes it look less like preservation enforcement, and more like damage control. Blake's motion tries to frame this as if she finally uncovered proof of misconduct only recently, after supposedly overcoming these major discovery hurdles created by the defendants. But this framing deliberately leaves out a key fact. The court already heard this argument months ago and rejected it. There is nothing newly discovered here. It's the same recycled theory dressed up in more dramatic language. Her filing claims that all defendants used Signal to discuss matters connected to the litigation. Therefore, those chats must contain incriminating discussions. Therefore, their disappearance must be intentional. But that is pure assumption. Courts require proof of content, not speculation about what someone imagines was in a deleted thread. The only direct admission she points to is that the auto-delete feature was active, which Judge Lyman already ruled does not equal bad faith. Then she leans heavily on the fact that she first requested the messages in February, and that the parties agreed to manually review communications in the ESI protocol. But that agreement still does not create messages that never existed or resurrect messages already auto-deleted long before litigation preservation applied. And months of hearings have already established you cannot produce what you don't have. She now tries to spin that technical reality as obstruction. In her motion, she writes, "For 6 months, defendants refused to produce any Signal communications and forced Miss Lively to repeatedly move to compel." But that's not obstruction. That's simply a lack of evidence. The court already ruled that the absence of these chats was not intentional destruction. Repeating the same argument won't magically turn absence into wrongdoing. She also claims the defendants admitted they didn't disable auto-delete, but that isn't a smoking gun. It's a design feature of Signal that countless organizations use for routine privacy. Unless she proves they discussed litigation after a duty to preserve existed, auto-delete is just normal business practice, not spoliation. She also tries to paint their rolling production, the handful of chats from after December, as defiance or self-help, but the court already held that post-December communications were the only ones that still existed. Producing them late may be sloppy, but it is not malicious destruction. Critically, none of these communications predate December 20th, the exact time frame she needs to establish her secret retaliatory campaign theory. So she's asking the judge not just to connect dots. She wants the judge to create dots that she can't prove ever existed. That is why courts almost never grant sanctions in cases built on speculation. She wants the assumption that the missing chats were incriminating, the assumption that they were deleted to harm her, the assumption that they contained sexual harassment retaliation evidence, the assumption that Wallace PR acted inside New York jurisdiction, and the assumption that the missing evidence proves her entire case. But assumptions are not evidence, and federal judges do not hand out sanctions based on narrative strategy. The biggest problem for her is credibility. The more she asks the court to fill in the blanks with favorable inferences, the more obvious it becomes that she doesn't actually have the material she claims was destroyed. And without proving content or intent, Rule 37E doesn't apply. and the court has already signaled as much. The Wayfair defendants are now arguing that Blake's legal team is trying to punish them for something they were never legally obligated to preserve in the first place. Blake's lawyers are claiming the defendants used Signal, voice memos, and non-auto-saving platforms intentionally so nothing could be traced, and that this supposedly proves a secret smear campaign. But here's the part Blake doesn't want the court to focus on. If she truly had evidence, she wouldn't need to argue that it was deleted. She's basically telling the judge, I can't prove my claims, so assume the proof used to exist. That is not how litigation works. Wayfair has already informed the court, in writing, that their first actual preservation notice wasn't issued until December 20th, 2024. And there is a preservation letter attached to the docket confirming that exact date. Meaning, before December 20th, 2024, they were under no obligation to save anything. Blake's lawyers are now trying to move the goalposts by saying the obligation started from a vague reservation of rights letter sent in November, something that is not a legal preservation trigger. It's a complete revision of their own previous position. In plain English, she's claiming spoliation, deleted evidence, because she can't produce any evidence to support her original allegation. After 9 to 10 months of discovery, after hundreds of subpoenas and dozens of depositions, Blake still cannot produce a single concrete piece of proof that a coordinated smear campaign ever existed. Even worse, she was accusing Wayfair of a smear campaign before the people she claims orchestrated it were even hired. This timeline alone destroys her own narrative. And now she's pivoting to, I can't show you the evidence because they used Signal. If a judge bought that theory, it would essentially criminalize anyone who uses Signal, iPhone voice memos, WhatsApp disappearing mode, or any private messaging platform, which is an absurd legal stretch. This isn't about sanctions. This is about PR control and delay tactics. Blake and Ryan know that summary judgment is coming soon, and Wayfair is expected to argue that she cannot establish the existence of a smear campaign at all. So her lawyers are trying to get ahead of that ruling by setting up a narrative that the evidence was destroyed instead of admitting the evidence never existed. At this point, their entire case hinges, not on proof, but on hoping a judge will punish Wayfair for something they can't show was ever deleted. The real takeaway here? Blake and Ryan are indirectly admitting they cannot win this case on the merits. Not because Wayfair hid something, but because there was never anything there to begin with, and the part no one in her PR camp wants to acknowledge is this. If Blake actually had even one document, even one screenshot, that backed up her accusation of a coordinated retaliation campaign, we would have seen it months ago. You don't sit on smoking gun evidence in a high-profile lawsuit while your public credibility collapses. You present it early, aggressively, and repeatedly. But she can't, because it doesn't exist. So now the only strategy left is to claim, I can't produce the evidence because the defendants secretly destroyed it. That is not a legal argument, it's an excuse. Courts don't sanction based on vibes. They sanction based on proof, and she hasn't provided any. And here's the real irony. If she is now arguing that using Signal as proof of ISA misconduct, then every actor, producer, CEO, journalist, attorney, or influencer who uses an encrypted messaging app is suddenly guilty by default, with no evidence required. That's not litigation. That's PR warfare disguised as legal theory. It's also a trap, because if the judge doesn't grant sanctions, then Blake and Ryan will have nothing left to point to when summary judgment hits. And at that point, the court will have to treat this for what it actually is, a defamation claim built entirely on speculation and headlines, not documents or data. Wayfair's team knows this. That's why they're not panicking. They're waiting. Because once summary judgment is filed, they're going to show the judge exactly what's already obvious. There was no smear campaign. There was no conspiracy. There was no retaliation plot. There was no deleted evidence. There was just a claim Blake Lively couldn't prove, and is now trying to outsource to assumed wrongdoing to save it. The moment the court rules on this preservation issue, the rest of her case collapses behind it. This is her last lever.